and I said yes at the time, and now I'm thinking, oh my God, there's all these experts in the room, but I will give it my best shot. So I'm Karen Syrett. I'm Joint Head of Planning at Colchester City Council. Now, Colchester is a city, but it does also benefit from having a lot of rural hinterland, and is part of Essex, which people don't necessarily associate as having beautiful landscape, but there are parts that are. And within Colchester administrative boundary, we benefit from having the Dedham Vale National Landscape. In 2022, I was awarded the RTPI Head Planner of the Year. And when I was awarded that, I spoke about planning and how difficult it can be at times. Anyone that's been involved in planning knows that it's not for the faint-hearted. And I've been called various names over the years, some of which aren't repeatable today, but one I quite like is the Queen of Concrete. But I'm also, I think, following a particularly controversial public inquiry in the Dedham Vale, I like to think of myself, and I'm sure someone said it, a protector of the countryside. So I've got some interest there, despite what some people might think. So that's enough about me anyway. So National Landscapes, the new name for Area of Outstanding Natural Beauties, as of the 22nd of November last year. The new name reflects their national importance as intended to put them on a par with national parks and things. The new name also reflects the importance of the threats of climate change, how national landscapes can contribute to that, along with nature depletion. It's also intended to create a greater understanding of the national landscapes and to bring about awareness of them and the work carried out across them all. It's important that the rebrand, for everyone to note that the rebrand didn't, however, change legislation and didn't change national planning policy framework, planning practice guidance references. So you might still hear some of us planners referring to AONBs. I think it will take a while for the new name to be established. So just a little bit of housekeeping before we make a start. There's no fire alarm scheduled today, so if one does go off, then please evacuate the building. There's, I think, 4 exits I counted, 1 behind you, 1 to the left out of here by the toilets, and 2 through the main foyer where you've got refreshments. Toilets, as I said, just outside these doors and to the left. Hopefully everyone's had time for tea and coffee already this morning. There'll be another refreshment break at 11:10. Can I ask everyone to return to their seats promptly for an 11:30 start? You can bring drinks back in, but no food. So we've got quite a lot to cover today, and I don't think anyone wants to miss out on any of it. So today's programme, as I said, 4 great speakers. What we intend to do is take 2 at a time and then answer questions that people may have both online and in the room. If you do have any questions about the event, then there's a team of people from National Landscapes here. They have got particularly standout badges on, but if I could ask them to stand up or wave, just so you can easily identify them, thank you. So before we start, I just wanted to say to all those people that are online, could you turn off your cameras and your microphones? Use the chat function to add questions. We'll endeavour to cover as many questions as we can, but if we can't do so today because of the time restrictions, we will try and get a response to you afterwards. So without further ado, can I introduce the first speaker? And these parts I'm going to read out because I don't want to miss anything really important out. Andrew Baker works for Natural England. He joined the Countryside Agency from National Grid in 2001 and via a completely random set of events led the flagship landscape change monitoring report, Countryside Quality Counts. Following his conscription into Natural England, he developed and led the landscape objective, monitoring and evaluating for monitoring and evaluation stream of environmental stewardship, a project which went on to win a Landscape Institute award. Since 2013, Andrew has provided Natural England statutory advice in respect of a number of major infrastructure projects, including East Anglia 2 offshore wind farm, Moorside nuclear power station, and the A417 missing link. He's currently on a full-time secondment with DEFRA, where he acts as the planning policy lead for protected landscapes, whilst also working on the legislative changes from the Landscapes Review. So using this knowledge and expertise, Andrew is going to tell us all about the new duty for national landscapes.
Yeah. I don't think Bill's had quite so much before that. So I need to say, first of all, I'm not a planner. I'm a landscape architect. I'm sort of wandered into this role completely by chance. So at certain points, if I wing it, that's the reason why I have no professional qualifications or memberships to worry about. Very quickly taking through what happened about 4 or 5 months ago now, in terms of the Local Regeneration Act and the new duty that came out of that on local authority and also the associated powers.
Could you speak up a little?
Put the microphone round to the front. Okay. Is that better?
Yeah.
Hurrah. I'm trying to keep my Brummie accent down as well, because that would completely confuse everybody. So I'll quickly take you through, because time is pressing. So that's what I'm talking about. And this is structured for the next 20 minutes or so. I've got a lot of slides and they're all word heavy. So I'm going to make them available afterwards. So please don't actually need to write anything down or try and track anything, and so not read it because there's an awful lot there. I'll concentrate on some key points. And then we're doing questions immediately afterwards or at the end of the two of us.
I think at the end of the two.
Yeah.
End of the two, fine, okay. So I'll take you through 3 things. Have we got here? Lord Randall's amendments of September 23, and what the new duty refers to, and also the associated powers as well. Okay, so how do we get here? Well, we're going back to the Landscapes Review of 2019 when it reported. A lot's happened since then. Some of we don't wish to remember. But essentially, there were 3. Well, there are a number of locations within that report where references made to the need to strengthen the previous duty on relevant authorities in respect of the statutory purpose of protected landscapes, so national parks and national landscapes. The previous duty was to have regard, which was generally considered to be too weak, and I think the AOB's marine representations to that effect. And it also recognises the need to do more with the management plan. And essentially something was felt that needed to be done to actually bring relevant authorities more on board with the statutory purposes of national parks and national landscapes. Okay, so there are 2 proposals in that in specific. You can read the details there. And then in 2022, following a period of consultation regarding the Landscapes Review, the government came back with a number of recommendations of what should be done. And one of the recommendations was that the duty indeed was weak and something needed to be done to strengthen it. Now, there's a whole story to be told about what happened next, but I'll skip through that. Just move us on to the Randall amendments of September 23. So the Local Regeneration Act was the vehicle that was available to actually change the statute. We are talking about changing 3 acts, and I'll come to those in a second. And the way in which it progressed through various reasons was that Lord Randall and friends came forward in the Lords and proposed a hostile amendment. And this is the 3rd attempt at doing that. And it essentially looked to do two things. One was to strengthen duty, and one was to grant a power to the Secretary of State to create regulation to effectively direct the local authorities in the operational duty. Following backwards and forwards and doing and throwing, that hostile amendment was agreed to by the government, it was accepted as a government amendment, at which point myself and the team I work in were charged with converting this hostile amendment into appropriate wording to go into the Urban Government Regeneration Act. 3 bits of landscape, 3 bits of legislation. It's amended. Now, it's important to bear in mind we only tackled certain specific sections of these 3 acts. The 3 acts themselves, the vast majority of it was unaltered. These 3 acts. Just as a reminder of what the statutory purposes are, I'm sure you're all very familiar with that. Okay, now this is the interesting part. The definition of what a relevant authority is. And the duty applies to relevant authorities. And as you can see there from the text in bold, that's a very, very broad definition. We estimate from a rough analysis, there are approximately 10,000 in England to which the duty applies, of which around about 7,500 are parish houses. In terms of those relevant authorities who have an active interest in the duty as part of what they do, we reckon it's around about the 1,200 mark. So very much a subset. And what does section 245 do? So we came up with wording in agreement with the departments and the Office of Parliamentary Council, and essentially this is what section 245 does. Places a new duty on relevant authorities. And it also grants a power to the Secretary of State to make regulations. 2, Director of relevant authority in compliance with duty, where I set out how the management plan to contribute to chapter 21, Environment Act 21, and you can read the rest of it as well. And importantly, the final bullet point provides flexibility about how the regulations are drafted. These are quite broad, encompassing powers, and we have not yet gained, well, the submission went up yesterday, to gain authority to start moving ahead with the regulations. And we reckon it's probably going to take around about 2 years to do it. And bearing in mind, we've got quite a lot to get through in the next 2 years. So, more than 2 years. Okay, so what does a new duty say? Effectively, the wording changes quite subtly. A lot of the original wording from the 49, 88, 95 and 2000 acts around the duty remains in place. What changed was must seek to further the specified purposes. Specifying is a word I've added in just to make it clear. So the previous duty was to have regard, and that is the duty which still applies to the devolved Welsh authorities. There's all sorts of issues on the Welsh-English border which I won't go into here over in the east of England, but it's an issue over in the west. And that duty remains, which was to have regard, to think about, to consider, and that was about it. So we have a situation now where the Welsh deputy landscapes and relevant authorities moving by are subject to one duty, and the ones in England are subjected to another duty. Which is not particularly elegant, but that's what we're doing. Okay, so the next 4 slides. And I've rattled through that at quite a pace, I do appreciate it. And where we are at the moment, because our intention is to issue interim guidance on the operational duty, so everybody's clear about what the intent is. Because the regulations are still potentially 2 years away, and there's quite a time period between the two when duty is enforced. Duty came in force on 25th of November last year. 2 months after royal session, royal assent. And so we're quite concerned that there's going to be a gap where people effectively are trying to work out what the duty means. And rather than everybody to be confused or go to the courts or whatever it might be. We want to give some framework for considering what a duty actually is. So having had quite a long conversation with our legal team, we feel that the duty essentially means the following. So it's an active duty rather than a passive duty. The sense we had from the duty of regard was it was very passive in operation, and little was required, whereas the duty to think to further refers to something which must happen, must be endeavoured to be undertaken. So we're characterising it as an active duty, not passive duty. It's going to be more outcomes focused, it's going to be about activities happening on the ground, rather than just a process to be followed, which again we felt was a characteristic of the previous duty. Significantly, it underlines the importance of enhancement as well as conservation. The operation of previous duty tended to boil down to measures which looked at opportunities for conservation. Very rarely, particularly in planning work, which is my background in this, did we see situations where enhancement was going to take place. In fact, of the 25 NSIPs I dealt with in 10 years, I can probably think of 2 where enhancement was actually part of it. It's very unusual to see enhancement measures coming forward. So the new duty is also about seeking opportunities to enhance natural beauty of national park or national landscape. And we want to make it clear that we think that relevant authorities should be able to demonstrate that they've undertaken this consideration, this duty, because we're quite mindful that the opportunity for challenge towards relevant authorities will be much more significant now as others seek to, if you like, take the opportunity to see enhancements and conservation activities do come forward when relevant authorities undertake functions in protected landscapes. So the ability to actually document that and have reference to it, have evidence to it, we feel is very important. So we all know what's going on. The last thing we want is also time spent uncovering what the activity might have been. Lots of words there. It repeats what I've said to a large extent. But as you can see, we're trying to give some sort of direction to what relevant authorities should be thinking about doing. And also we're going to emphasise the importance of the management plan. And if we skip back to the powers that the Section 245 grants the Secretary of State to make regulation, 2 of those powers specifically around the management plan and the role of the management plan in targets associated with the Forest Act 21, and also ways in which relevant authorities can use the management plan to help them seek the relevant purposes. So the role of the management plan is going to be much greater with the new duty. That's our thinking at the moment. Again, that's what our thinking is. And so when we're talking about the outcomes framework, objectives and targets, which are coming through the management plan, the relationship between the new duty, regulation, and the outcomes framework is a sort of triangle going on there. And that's the thinking we want to start to develop in the next 18 months or so as we start to work at the regulations. Again, issues regarding mitigation measures. Second, I'm sure these sort of words are coming with the plans in the room. And again, this emphasis on going beyond just replacing one-to-one replacement, thinking about opportunities to enhance. And clearly, yeah, relevant authorities, buying authorities, local plans and relationship between the local plan and the management plan, if in one of the areas we want to explore within regulations as well. But it's not only planning that the strength and duty affects, it's also those day-to-day activities which relevant authorities undertake. So if we think about some of the statutory undertakers, Network Rail, for instance, electricity companies, those who are operating infrastructure or managing land within a designated landscape, or within a protected landscape, how will the duty interact with those activities? So we're trying to emphasise the thinking that some relevant authorities will need to start doing to understand how their day-to-day activities interact with the new duty. Now, clearly, when we've got 10,000 relevant authorities in the country, we can't be that specific for everybody. So we're going to have to work out a way.
Sorry, Andrew. I'm getting a few nestled. I think it's quite muffled. Can you my kids? Sorry.
That's all right. It's not.
Take it away. And it's not. Yeah.
I'm near at the end of, is that okay?
It's on.
Is that better? Sorry. I'm near at the end of my 15 minutes actually, so I'm just going to rattle through to the next one. Technology. Not the end. The end. Yes, no, twice. Yeah, sorry. So that sort of wraps me up. So if people have got questions, I appreciate I've rattled through a hell of a pace there, and the slides will be available afterwards for you to digest at your leisure. If any initial questions, I'd be more than happy to endeavour to answer. Yes. Thank you.
Good morning. Thank you very much, Andrew. I won't get up because I'm stuck with it. James Finch, I'm chairman of the Devon Vale National Landscape. Your first policy was active duty, not a passive duty to the local authorities. As soon as I saw that, can I read that as proactive?
Funny you should ask that, because I haven't debated about that in words at the moment with interim guidance, whether to use proactive or active. My thought is it's proactive.
Let's write it down then.
I've had to tone quite a bit of this down already to not sort of set other parties. So I agree, it's a proactive duty. The phrase "seek to further" to me suggests that something has to be done.
Can I just follow that up again then?
Yeah.
Who is managing, monitoring this or whatever?
Okay. That's actually quite a difficult question to answer.
That's why I asked this.
I know. Within the 1949 Act, there is a duty on natural inland now to monitor and report upon the operation of the duty. That's been dormant for a very long time, and natural inland, indeed countryside agency, and I suspect the Countryside Commission never did very much with that duty for the 49 Act. However, that duty was unamended by section 205, so that duty is still active. So that is one of the things we are considering at the moment. Is there a need to monitor and report, or is there not? And if there is, who does it? But it would seem to me the 49 Act provides a pretty strong clue who should do it.
Yeah.
Thank you.
Right, there will be more opportunity to ask Andrew questions following our next speaker. We'll take to both topics at that point in time, so don't really miss out. Our next speaker is Dan Oakley, who is a professional dark sky expert. And this is riveting for me, all this, and I've had to cut some out because of the time, but he's a professional dark sky expert and founding director of Darkscape Consulting. Long experience of working in dark skies, and he's passionate about providing services to protect our connection with the cosmos for people and our planet. Dan served as the Dark Sky Officer for the South Downs National Park Authority for over 10 years and was responsible for creating and producing all aspects of the South Downs International Dark Sky Reserve Status application, which included authoring the planning policies and the technical guidance. Dan currently sits as chair of the International Dark Sky Association, is a founder member of the IDA UK chapter, and a registered IDA advocate. He also established and currently coordinates a UK Dark Skies Partnership, which is an organisation committed to reducing pollution. He's been awarded the IDA Dark Sky Defender Award and received awards from the Commission for Dark Skies, amongst others, as well as the Worshipful Company of Lightmongers. I couldn't resist. So Dan's going to cover the lighting design guide for us. Thank you, Dan.
Thank you very much. How are we all this morning? Good. When the last time we saw a dark sky with this weather? No, I can't either. But we're still going to protect them. So I'm going to turn the lights down because there's a bit of a mobile phone exercise we can do at the end of this. You can understand all the lighting terminology that I'm going to throw at you in the next 15 minutes or so. So this is the document that I'm here to promote. It's the lighting design guide, and it was put out a couple of months ago. And it is quite a big document, and it will show you how to do good lighting in these landscapes. But there's a lot of information behind that. So this is what this talk is about, just promoting how to use it properly. I want it to be illuminated in a good sense of the word. I will go over some light pollution context, give you the metrics, tell you about the character of lighting, which is quite useful, how that applies to designs, and a bit of a mobile phone example. But what we really want to do is kind of avoid the proliferation of this, I don't know, monstrosity? I don't know, that's like a headache in 10 seconds, that place. This is because of the proliferation of LEDs. Everybody wants to put them on their house. Everybody wants to do better than the person next door to them. And we have to do something about it because it is just getting worse and worse and worse. I will first say, don't be intimidated. If you do any planning with this, you'll get lighting reports, and it's very technical, I won't lie, but it can be distilled into a couple of really easy to remember points, which is good. So these are just examples of what you find in good lighting design reports. You have the map of illuminance, what they're trying to do. You have the lights that they're trying to use, and then have the obtrusive light calculations to the side of it. It's all very engineering, it looks very pretty, and you're only looking for a couple of numbers in about 10 pages of numbers. But I will make sure you know the right numbers to look at. Right. Well, the mouse button stopped working. Doing that. I've got another ground in your things coming out. And the battery's gone.
Try these buttons here.
Yeah, do that. Yeah. There we go. Let's do that. Okay, so this is what we're trying to protect. I'll use that. Dark skies like this. Now, it's not about bagging lighting. Not at all. It's the right light in the right place at the right time, which is what this is. So this is a light under a dark landscape, and it's off. Could be argued this is the best kind of light, but what we're looking for here is a trade-off between good lighting and good dark skies. So don't put it in your mindset it's about banning light, because it's not at all. And what we've found is what once started as a purely astronomical issue is now much wider. So we now know that dark skies actually is a subset of light pollution, and light pollution covers many things. It covers the impact on nature. It's a nuisance in itself, the brightness through your windows. It's about energy costs and turning the streetlights off. It's also about your health and well-being, how the blue light affects the melatonin production of the Dracula hormone inside your head. But it's also about the way you interact with spaces. So it's not always about the dark, but it can be about the light as well. And this kind of leads into things like social justice and good lighting for different kind of areas. So light pollution actually does touch on a lot of different things. And we give it a nice acronym, we call it RONAN. It used to be ALAN, artificial light at night, but now it's turned into RONAN. So that's responsible outdoor lighting at night, and assures we can put a D on the end of it at some point and turn it into RONAN. But there we go. So let's get on to some metrics. So light pollution is caused by three main things. sky glow, glare, and trespass. So sky glow is the hot, horrible orange glow you get above cities. That's caused by the scattering of light going upwards and outwards. Glare is that horrible feeling when you get a bright light in your eye and you can't see where you're going. So think of all the modern cars that have got big LEDs and you can't see where you're going down those country roads. And trespass is where it goes into your windows or where it shouldn't go. So they are industries established light pollution sources. I think there's another one, which is presence, which is particularly pertinent to landscapes, and that is where you might have a really good lighting design, but just the presence of it being there is enough to cause concern. So think about a sports pitch. You can have a really good efficient sports pitch, but in the middle of nowhere, that's a big threat. So that's the three main ones today. So let's give you some other metrics. This is all in the report, the guide. This is about the technicality of light. Now, I won't go over this too much, but the two terms you need to remember more than anything are lumens and lux. So lumens is the output of a light bulb. If you put a bag around it and collect all the photons, that tells you about the intensity of the luminous flux that comes out. So in the higher the lumens, the higher the brightness. And what we want to do with lighting is make sure we have the correct illuminance for the job we need to do. That's measured in lux. So things like driving down the road, walking up steps, there are guidances that tell us what the appropriate lux should be for a task in most commercial activities. Doesn't happen in domestic because there's no guidance for domestic. But in general, you're asking a lighting designer to modify the design of his light with using up or down and the choice of luminaire to make sure he achieves lux. That's basically it. The other two, candelas and luminance, are a bit more complicated. You need to refer to the document for those, but keep those two in mind, lumens and lux. So the next character of light is the colour temperature. It's quite important. So as the sun sets and rises, it changes colour. We get much more orange temperatures in sunset and sunrise, although I haven't seen the sun in 3 weeks, so I couldn't really tell you about this. And what happens? The light actually mirror the colour of the sun. This is why they have such a high temperature. It's because they are kind of mimicking the actual temperature of stars. So we're always looking for 3000 Kelvin. That's the magic number. That's a trade-off between having good kind of colour rendition and not having too much scattering. Because the brighter the light, the higher up the scale you go, the more that light penetrates the atmosphere and creates sky glow. So that's why the sky is blue, because you've got preferential scattering of bluer and whiter wavelengths. So we want 3000 K. That's the other important number to remember. Related to this is the colour rendition index, or sometimes abbreviated as RA. This tells us how colours are washed out. And we're always looking for a magic number of about 80 with anything, because 80 is usually the limit for things like CCTV. Because CCTV needs a certain colour rendition so they can prosecute. They have to have lights that achieve that level. The old sodium lights were down at 20. So that's why we've got a proliferation of whiter lights. Good thing is now we can get 3000 K lights that meet 80, which is fantastic. It's exactly what we want. So that's another thing just to consider, RA of 80, which again is in the guidance. Put that all together, you've got some good basic principles of lighting, and this is for anything, for domestic lighting, commercial lighting, Wembley Stadium, anything you want. And it's just some really basic principles. So we want to make sure the light is useful, has to have a purpose, has to be doing something. We want to make sure it's targeted in the right direction, that the light is going where we need it and not in the air. We want to make sure it uses the lowest light possible. So we try and aim for domestic purposes at around 500 lumens, roughly equivalent to a 60-watt bulb. But also we want the right kind of illuminance with that and the right guidelines. We want to make sure it's controlled. It's often when we don't need it. It's designed where it needs to be. So designers are used to help control those things. And again, it has the right colour temperature. So you will see these things, these kind of concepts all throughout guidance in some kind of form or other. But that is the mainstay of good lighting design. And you will see that in pretty much everything. So just to see that graphically, what that is, this is the kind of picture of putting all those things together. Here you have a picture of bad lighting. You've got a light with a lot of backlight still, it's causing a lot of glare, it's going into people's windows, there's a lot of upward lights. That kind of shows that graphically. However, if you do the 6 principles, you get a much different impact of lighting. You get the right kind of light, it's the right kind of colour, your neighbours aren't annoyed, you're not ruining the stars, and you're not bothering wildlife. but you still have the light that you need. But this is why it's all about the right light, the right place, the right time. So this is a bit complicated. So what we try and do in the guidance is make things a little bit easier. And we try and do some kind of cheat sheets. So this is one of them. This is two kind of postcards that we use in the South Downs and we kind of modified for this. But this is a postcard that are aimed at domestic users and one aimed at commercial users. So all the domestic users get the principles pretty much as they were, using the right kind of light, making sure it pointed it down. But for commercial purposes, what we need to achieve a certain illuminance, we have other things. We want to make sure we have the right kind of lighting, we have the right kind of illuminance, the colours, and the type of flows of business. So this again is in the guidance, it will help you understand that. And where it gets a bit trickier is when you've got the landscape itself. So in a dark landscape, lights look more prominent, which is a problem because you're going to have an impact, how to view that as an impact of dark skies. So this is an example of exactly the same light in different contexts. So in a rural setting, that light will stand out like a sore thumb. But in the middle of London, you won't even know it's there. Even though it's achieving the same luminance, the same levels of lux, everything's the same. So when you do your assessments, you have to bear this in mind because it also this added weight of the presence of the light having that effect. And that is more subjective, unfortunately, but the guidance will help you kind of make those arguments. The maps as well, the dark sky maps are always useful there in the guidance, and they will show you where the areas of darkness are. And this is just from the satellite information. It tells us where anything that's blue is darker, and you can see the Milky Way, which is great. But what we've done with the guidance is what other places do is turn that into policy. And we use a document called the Obtrusive Light Guidance for the Institutional Lighting Professionals, which is this thing here. And that is really the document that tells designers how to do lighting design properly. And it applies environmental zones, E-zones, to different places, and it tells them how to do upward light, trespass, all those kind of things. So we haven't really referenced it too much because you can download that somewhere else. But importantly, we want to make sure that every single light in these dark landscapes is pointing down at a minimum, because there's no excuse. All the LEDs these days point downwards, right? So any kind of planning you do, any kind of lighting you want to put up, zero upward light is best. But that still can be a bit complicated. So what the guidance has got is just some handy little graphics of certain kind of scenarios. So this is one of the commercial property. And what we've done here is just highlight all the major issues that you get with commercial lighting. So you've got lots of theatrical lighting, you've got decorative lighting, you've got car parks, festoons, and all of these things add to the problem. So what we want to do is create a nice opposite image that tells you how to implement the 6 easy principles, and you get much better lighting control. They still have the lighting that they want for their business, but it's the right light in the right place. So just as an example, all the lights are now pointing down. If they are using upward lighters, it's always aimed at the building, it's not going into the sky. The illuminated signs, which are a bit of a bugbear of mine when you drive around, because people like to advertise their businesses at all hours of the night. It's off and it's in the right kind of setting. So the guidance has got lots of different kind of examples of case studies, basically, which you can use. Added to that, we've also got better guidance on what the best lights to use in these circumstances. So we want to avoid these horrible knockoff things that come off and really, really bright and blind you and actually put out more light than the street lights. But for some reason, we want to put these in our back gardens to cook our sausages on the barbecue. We wonder why we get annoyed at it. We want things that point down in the right kind of temperature. So again, the guidance has examples of the best and appropriate lighting to use in the right circumstances. And it's different for each one. So this is a bit more domestic and a bit more commercial. You've got commercial lights at the top, but the higher you go with the commercial need, you can get different lights, that kind of thing. So that's hopefully you guys educated. But what about the designers who are giving you this information? Well, fortunately, they're getting better at understanding lighting design. So if you get a good lighting designer or a good architect, they will use those principles and do good lighting. What I found in the South Downs is because it's written in the language of lighting designers, they understand what's going on and they just do it. So they're getting really good at doing it. I'm having to find out a lot less conflict in later years with designers because they know exactly what to do, which is great. The problem we get into is when it's a little bit outside of their domain. So architects are a bit of a problem sometimes, so are electrical engineers, because they just don't really have access to this. So for lighting designers or any kind of planning application, you kind of want them to make sure they They do the right things in the right order. So you want to make sure that they are being guidance led. They are following industry standard. But then again, you want them to make sure that they're doing the right things to the landscape. You want to make sure they're doing the right kind of wildlife assessments, ecology assessments, and sky quality assessments if you want them to. So this is kind of like how we kind of build in the roadmap for a designer to do the right thing. And you can use it yourself, but I will just stick to the 5 principles if I were you. But thankfully, this is getting more and more industry standard now. So this is less of a problem, but it all still comes down to the presence of lighting itself. So you've understood all that, hopefully, right? You got it all? I can tell, brilliant. So how do you interpret a lighting report? This is what comes in with a planning application, but you can see it's numbers and colours that mean nothing. Well, fortunately, a good lighting designer, having read the guidance, will go, right, I need to make sure I emphasise a couple of numbers to make sure that they understand how they get planning through. So the first one is I make sure they include the luminaire, thing like that, and it tells you exactly what the car temperature is. Brilliant. You just find a number on the product sheet and tick it off. It's also got the CIRI number there. It says it's 80. Brilliant. That's something else you can tick off really easy. You don't have to worry about anything else. The little polar diagram there tells you that the light is all coming down because the bubble of that plot is coming down from the horizontal line on that axis. So again, you know it's downward pointing light. Excellent. But what about the design? Well, fortunately, this is what I did. I referenced the guidance I was using, industry standard, and it told me I had to achieve 10 lux. And I did, which is great. So that shows me now that they've done the right thing. It's a justified and well-designed light. And the colours are just telling you where the different illuminants, the lux levels are going. Although I've got high levels of lux in the middle, that's just where the light is. But the average is still 10, is still 12, which is great. It shows me that it's well done and constrained. Something got it? Fine, perfect. Because this is the bit I would encourage you all now to get your mobile phones out. But what I want you to do is we'll have a little lesson in putting this all together. I want you to turn the torch on of your mobile phones. Right, so what you want to do, this is a little exercise we've got, is the exercise is you've been given a lighting design that a client wants to write something incredibly nasty about the person sitting next to you. So you have to make sure that the lighting is only focused on the bit of paper on your lap and the person next to you can't see the horrible things you're about. All nice things. Let's do it both ways. They're going to write about you. So at the moment, let's start up with a really, really bad design. So let's just hold our phones up in the end in a stupid way. You can see, if you have a look around, it's badly installed. You can see it reflecting off the top of the ceiling. So let's do the most important thing about dark skies, point the light down. And you can see the difference already in the ceiling. Yeah? So that's just having that first impact on that. The next thing, we need to make sure we've got the right level of lux for the purpose we're doing. And I've downloaded the how to write something nasty about your neighbourhood lighting guide, and it's told me I need to achieve 5 lux. So what I have to do then now is I can start to lower my lights to make sure all that light is just now illuminating the page in front of me. But as you notice, the illuminance is going up on your bit of paper. Right, so it's gone from, let's say, 5 to 20 lux as you bring it close. So you've managed to constrain the light trespass, and it's now not going into your neighbour's lap. But what we have to do now is adjust the brightness, the lumens coming out of the light, to make sure you achieve the average of 5 lux. Now, if you're lucky enough to have a phone that you can modify the intensity of the lamp, I can't on mine, that's how you would do it. You would just adjust it until you had enough light that you needed just to do that job. Right, it'll be quite a lot lower. And if you're very lucky, you've got one where you can change the colour temperature as well, and you adjust that to a nice warm white, about 3000 K. And that's basically how you do a lighting design. You've got the light you need to buy, you know what you need to light, you just play with the lux, play with the height, make sure you achieve the right levels of luminance, and make sure the light is all constrained to the area that you need to do it. And that's what you're looking for in a good plan. And lighting designers will generally do that, but in domestic lighting, there's no requirement. So you have to be a bit careful when you get new builds, new housing estates, because they will want to put up lighting on their own. So you have to make sure it's all doing that. So hopefully you wrote something nice about it, neighbour. You also did bad, and how much this talk was brilliant. But there we go. So that's it. I think that's my 20 minutes. I'm not sure if there are any questions afterwards, but now you're all qualified lighting designers. Thanks very much.
Yes,
Right, thank you. I think we've had two very interesting speakers so far this morning. I'm not quite sure how this mic is going to work for Q&As. Now we've only got one. But, right,
Karen, could you use the,
one of these.
I don't know whether the lapel mic has
I
gone.
can just run it back.
We can,
But hands up first. Let's see if we've got any questions before I start to panic about the logistics. Right, I've got one there.
could you share this with the,
Yeah, a quick question. You said there are no rules for domestic housing lighting. Should there be, and is there any prospect that there will be?
It would be nice if we were, if we follow the example of the French, then yes, because they have laws that relate to domestic lighting, but we don't. Because under planning, it's minor domestic, minor lighting, which doesn't really include little tiny lights on the side of your house. If they are a nuisance, then yes, you can go down the route of going through kind of like environmental health, but generally there's nothing to stop people putting lights on their existing houses. I'd love a bit of policy to, if that were the case, which is what we're working on with the partnership, even if it's just to adopt those principles to have the right light in the right time, the right place, and just using appropriate lighting. What we don't want is those horrible, cheap, nasty knockoffs that are popping out 10,000 lumens to water down a garden path because you don't need it and it just annoys everybody. If it's just that, then that's good. But at the moment, it's more about influence and awareness and taking that little postcard and shoving it through your neighbour's door secretly and hoping they do the right thing.
Can I just ask a follow-up to that, because it was something that I was going to raise as well, having seen some horrendous photos only yesterday of a local site. And are there examples elsewhere in the country where planning policies have been used to assist in decision making? I know we can't take away permitted development, but to help in decision making in national landscapes or elsewhere.
Yeah, so I think from my experience in the South Downs, I'm still there planning consultant lighting. So we get all the applications that come in, and we do get quite a lot of domestic housing estates. And a lot of them try and condition the lighting afterwards, or they won't even bother with it. And I try not to do that, because you don't want to put the hands of people popping up with bad lighting themselves. It's actually better for the designer and the architect to put good compliant lighting. People do need lighting. And if you put it up correctly, that means the tendency to put up bad lighting is avoided. So there are ways around it, but that's only for new builds. For existing builds that you just put inside the houses, I've not heard of anything that really does that.
Thank you. Got another question?
Hello, can you hear me?
Yeah.
Nick Miller. Can I go back to the previous speaker? Mr. Finch raised a question about who would enforce or whatever is the right word, monitor. Talking about planning permissions in general, not just protected landscapes, there's always a question of whether the wonderful plans of the government are actually ever enforced by the district councils. I gather there is, under this legislation, some provision for local authorities to be required to enforce and for them to be funded to increase their enforcement. Is anyone else's experience here that planning conditions about biodiversity, net gain and so on, at this stage in the game, just don't get enforced?
I have to sound afraid I can't answer that question, because that's not my area of specialism, and it's also, I suspect, could be quite a long answer. So I'll have to pass on that, I'm afraid. And again, with biodiversity net gain, I think we're in a very early stage at the moment, and we have, 375 odd local authorities in the country. So there's going to be 375 different versions of doing it, I suspect. I'm afraid I can't give anything more than that. Sorry.
Hi, John Mills from the Consultancy National Landscape. Got a question about lighting. You, at the start of your presentation, you highlighted the issue of presence in terms of less elements in the dark landscape, if you like. To what degree and how does the guidance address that issue?
That's an interesting one. Is that on? Can you hear me all right? No, I've gone deaf. Are you on mute? Again. It's a good question actually, because there's hardly any guidance for, let's say, the residual effects of lighting. So that's what I'm trying to fix with some other projects I've got going and other guidances. But what you're kind of asking to do in this guidance is to kind of make sure they do kind of a nighttime landscape impact assessment. So they can kind of visualize it, and some softwares can actually kind of like model what it would look like in the landscape. And that's important because it gives you kind of flavour of how that might disrupt the continuity of the landscape. It won't tell you a lot about the sky quality, but it'll just show you the effect of where it would be in a darkened kind of countryside. It's a real problem because it's never really been thought of. So even the institutional and professionals guidance only doesn't really deal with it because it's all about lighting design for people. It doesn't do anything about landscapes or wildlife, which is a real tragedy. So whilst this guidance has got kind of like a bit of a consideration for it, and it's something you could use to ask developers to kind of consider, there's nothing really to say what are standards for what is negligible, what is minor, what's a major impact in the landscape. So that's something I'm trying to work on. We had a case in the South Downs where we had a charging EV station right next to our core zone. And the developer was saying, well, this is kind of a negligible impact. I said, well, no, it's not. It's actually going to have a moderate impact. We made our cases, and interestingly, the planning inspector went right down the middle and said, well, actually, I think it's going to be minor. So he took the kind of middle route, which was fine for us. The whole thing got approved for them anyway, because I had a different reason. But on the lighting side of things, it was good to see it was acknowledged that the planning inspector said, well, actually, it's not going to be negligible due to the constraints of the guidance that we've got. But if you can take it from a landscape point of view, there's something to consider there, and it is a minor consideration. So there is got some, maybe it's just not as robust as the actual physical optics of the efficiency of the lighting. Any more questions?
Robin Coates, Worcester Parish Council. You mentioned that the colour spectrum of 300 colour temperature for 300 Kelvin was the best one, but you seem to indicate that was for the spreading of the light and distribution of light. Is the same colour temperature the best colour temperature for wildlife interaction?
Let's go with this one. This on? Yeah, so for wildlife, you can drop to lower colour temperatures. So the Dark Sky International advocating 2200, which is a bit low. So it's almost the kind of same colour temperature as the old sodium lights. The trouble is when you get that is then you start to interfere with the colour rendition index. And what people are finding is when they're out on the streets, they want to be able to perceive colour properly. It's a bit of a safety issue for some. And what you don't want to see is just kind of like greyed out people. Because if you have got CCTV, they need to be able to distinguish the colours properly. So that's why there's a tendency to have the whiter light in cities. As you get further out into the countryside, then you possibly adopt those lower colour temperatures. Having said that, they're not for everybody. There's a good example in, I think in Denmark, where they had a bat conservation route and they put red light up, so really kind of low colour temperatures. And it was great for the bats, but they realised it would start to kill the crops next to the road. So it was good for some wildlife, but bad for others. So it's emerging evidence, but if you want to try and do your best for wildlife, for any wildlife, including us, get to 3,000 first, and if you can make further gains without interrupting the design, get it as low as you can. But that may need a consultation on what is an appropriate feed conception of the light as well.
Okay, Councillor Finch.
We just got a couple of questions from the chat online.
Yeah, do that.
Thank you. We have a question here about how a small household application, an extension or something like that, might be accepted to approach a new duty.
Very, very simple. The duty doesn't apply to private individuals or landowners. In fact, it applies to essentially public bodies. So if the extension is being done through a PDR, then the duty doesn't apply. If the extension is being taken through planning permission, it's an application, and the duty falls upon the local authority, the planning authority, to discharge it. Obviously, should that extension be within a protected landscape?
Second question is, can you just confirm that the strength in duty applies to departments like licensing?
Our understanding of this, yes, it does, because licensing is essentially an authority.
Okay, and the third question, it's about the difficulty of doing like-for-like measures of lost features on, say, a greenfield site that may not have them, and how are councils to be guided on substantive enhancement to counterbalance harm to an undeveloped character.
In one or two sentences.
Yeah, we can follow up. I mean.
Yeah, I think we're going to have to. That is the area where we are having to work our way through. Right? Because when you get into the detail of this and individual cases, then that's when it's going to be more problematic, I suspect.
Thank you very much. Lovely, thank you. This is all about historic circumstances, not that historic, but development that was developed in the last 5 years. Suffolk County Council has got a lighting policy whereby we turn the lights off at midnight and they come on at 5:30. I would throw them later, but anyway, that's what we do. There are certain developers that have not met that criteria, and therefore the scheme of that lighting is not adopted by the county council. That is in, by the way, the national landscape. They're the very efficient landscape, and all the lighting in that village follows what everywhere's dark except this new housing estate, 30 houses. Is there anything we can do within the legislation in terms of retrospective enforcement? Because otherwise that's going to be like that forever. And the second thing is, I know that Bev Ears has specifically requested that is a definite enforcement action on the planning to make sure that you do meet those things before they get planning on the whole site.
Do you want me to start?
You don't do that.
I can maybe start. There was lots of points there. I think retrospectively on a completed development, we would be struggling to take any action.
That's the point of asking the question. We've got to decide how we do that nationally with national law.
Yeah, okay. Shall I respond to the other points about, right. So what Dan did refer to is possible enforcement action through another body, environmental protection probably. So if there's a nuisance caused, then that might be an option. But I think the key thing is to ensure that on new developments, then there are conditions which are applied and adhered to. Dan referenced seeking those details up front. That might not always be possible, but you can still insist on appropriate details after permission has been granted. So that's one aspect. Then there is the issue of planning enforcement. Generally, council resources are quite squeezed. We rely on other people telling us when there is a problem with planning being implemented. And that does happen. But sometimes we have to work within the regulations, which comes back to your point. It's about national legislation and how that can be enforced, really. And, you know, some of the principles Dan spoke about to me seem quite simple if it was a requirement at a national level to implement them. You know, not just in a national landscape, but there's benefits there wherever you might be. So, yeah, that's probably over to you as a councillor to do some lobbying, I
Yeah.
might suggest.
Well,
Anything to add, Dan?
Yeah,
Beverly, help me, Nick, wouldn't you?
I mean, I've seen, county councils with highly varied approaches to street lighting, so, not surprising, the ones that got some dark sky reserves in them, they all make reference to the reserves and darkness to make sure that any lighting design adopts the council spec, which has the right kind of guidance in it, so they all pushed into that. I would say that some councils, due to the money, don't necessarily integrate isolated villages into the wider kind of control mechanism network. So some places just don't receive that kind of smart lighting and they can turn it on and off again. But again, it's the best way to try to catch the hat before it comes in and make that part of the application. But again, retrospectively, one of the ways I would do it as a dark sky advocate is get the local community to want to turn their lights down and put pressure on the.
We've got that, we've got that.
Yeah, so just keep going with it. And if they come up with an example saying it's for safety, it's this, you can just tell it it's not right. It's just your laziness that doing it. It's, you can do these things without jeopardising the
Can I come back to the real issue? The real issue is, it's actually with the developer who has the power to either do it or not do it, having got planned. There's no incentive for him to do it. That's the problem.
But there would be an incentive if either it was in national legislation, which it's not at the moment, but if planning policies, and we heard about aligning management plans with planning policies in new local plans, then you've got the policy hook in which to make planning decisions on application and include those conditions.
Going forward, I agree with all that. It's how we handle this, what can I call it, this sort of, this one area which, unless we can do something, it'll be like that forever.
Yeah, and unfortunately, permitted development allows for a lot of lighting. There's some horrendous lighting schemes out there and we can't do anything. Our hands are tied at the moment.
Can I pass the message back up top to try and get to help us, basically?
I'm afraid I have to well, state that permitted development rights is right in their continued extension is the direction the current government wants to go in. So within DEFRA, we do a lot of lobbying within the department to essentially the LUC who have the planning responsibility in government around permitted development rights, and that is an ongoing conversation. But it is the direction of travel of this particular government to roll back the requirements for planning and go towards TDR. That is just a fact, I'm afraid.
I've seen two hands up. We've got 3 minutes, so we might get them in if they're quick questions and answers.
Hi, just with that one in mind, it would be to speak to the people in the guys with the lights. They can put filters on the street lights, which will take the temperature down. Timing wise, I don't know how to do it, but you can actually put the filter on the street light, which will take the temperature down. It's probably about 4,000 now. You can take it down to 2,700. Lighting design.
I won't go on.
Over here.
Thank you. This is super quick, don't worry. I'm a local councillor in Suffolk Council, and it's not really about that. It's about my opinion actually. I'm trying really hard to. There's a care home, newish care home, about a year old, it's probably older than that. Time flies. In my ward, and I'm trying to get them to turn they've got these awful uplighters, not even downlighters, some of them on the outside. They really were disturbing the neighbours directly opposite their sleep. We worried about bat colonies. I mean, quite a lot of trees are demolished to put this care home on. But I'm just amazed by their attitude, their cavalier attitude, towards the locals and to my police. They have turned down a bit. They're still pretty bright. It's bizarre because they're lighting the outside of the building, and the elderly mostly elderly residents, they're not going out wandering around at night. Visitors are driving in, so I'm mystified who these lights are actually for. I'm also mystified that they want to spend the money on keeping these wretched things on all night. It's completely peculiar, and our planning team don't seem to have been very motivated to do any kind of enforcement. But I guess it comes back to what's been said already. The national legislation, the political will is missing, isn't it, from these things? There's a general election hopefully this year, folks. I mean, I'm just not going to say more about that. Thanks.
Which I can come back to.
Oh, yeah. Bedford's got an answer.
Yeah, quick response to that.
Yeah, I was just going to as well.
Oh, okay, you've got.
I just wonder actually if it's worth speaking to the environmental health team about trespass, potentially a nuisance factor. It's hard to prove, but it might be another avenue if you haven't.
You're right.
Yeah, so the environmental health will be really tricky because it's all against the neighbours, not people in residences, and it's so low that I doubt you'd get any comeback from that because you're ultimately undermining the purpose of the first place. But the reason why they've got the lights the way they have, insurance. Because the insurance company is saying you've got elderly people in that house, in that building, that might be outside. If they fall over, it's your fault. Therefore, they do. It's the same with farms as well. They're told by the police, do it for insurance, and they like the countryside. They don't need to, but that's principally the reason for it. They want to cover themselves.
Basically, didn't tell me that. Thank you.
Well, they probably don't know themselves, but they just, the designer will probably go, well, I have to meet this criteria. They want lighting to make these people safe. I'll do their lighting design. If they haven't told me to do that, then they'll do it the way they see fit. They'll just put those lights up and won't turn them down. And they
don't need to be up. So they can be.
They don't, no, they don't. That depends whether or not it's gone through a design process. What we can do is you can, because we had a care home in the South Hams, and funny enough, we just said make sure the lights are all pointing down, make sure the emergency lights were compliant as well, and just you don't need the rest because you're right, no one else is going to be there. It's just for their vanity. But we did make sure they had the right light to keep their residents safe. That's really important because if there's an authority, you tell a designer to do something different, then you're potentially liable for what happens to those people in the design. And it gets really, really sticky. So you've got to, from both parties, you've got to keep yourself safe. So,
Right, thank you very much. I think we're pretty much on time, so thank you everyone. Some really interesting questions and answers there, I think. Could I ask you before you go for teas and coffees, to come back to your seats promptly for an 11:30 start, or to your laptops for those people elsewhere. And could I ask you to please show your appreciation both to Andrew and to Dan?
Thank you.
Oh, yeah. In this over now, but people do that.
That's wonderful.
if people use it, obviously they really need to be, yeah. If, but I mean, I know that's a bit on the surface, but it's working. Yes, yeah, yes.
Welcome back, everybody. Just let you know that while people are taking their seats, the lighting guidance, if anyone is interested, and I'm sure you are, is available on the National Landscape website. And the team will include a link to that when they circulate the feedback form, which, in case I forget at the end, please fill in the feedback form when it comes around to you after the event. So we're now going to hear about nationally significant infrastructure projects, or NSIPs, as they tend to be abbreviated to. This is from Isaac Nunn of Suffolk County Council, who's a senior planning officer and represents County Council's interest in respect of NSIPs and in the planning process. Isaac led the council's response to a large solar NSIP, which is located in the Suffolk-Cambridgeshire border, and is also currently leading on Sizewell C nuclear power station. Welcome, Isaac. Somewhere? Oh.
Hello. I'll be able to see it. Okay. Excellent. Hello, thank you very much. So yeah, as the chair said, I'm a senior planning officer at the Suffolk County Council. I work in the County Council's NSIP team, and in Suffolk we've dealt with quite a lot at some kind of national conferences. We have in the past been described as NSIP Central because of the huge kind of volume and variety of NSIPs that we host. I think we may have been overtaken in terms of quantity by some other local authorities recently, but I think we're still very much up there, especially in terms of the variety that we get. And a great many of those are obviously located within the National Landscape area, because a number of the major energy projects, such as Sizewell C, the offshore wind projects, and therefore grid reinforcement projects to support those, will also run through those areas. So I'm going to walk through a little bit of an introduction to NSIPs. I'm not going to go in excruciating detail into the whole process in terms of how they're decided, but I will cut some kind of interesting differences for the Town and Country Planning Act regime. I'll spend a fair bit of time going through some of the interesting policy points from the national policy statements, because it's a whole new kind of suite of policy that you may not be used to if you usually deal with the Town and Country Planning Act regime. Some of the slides I've got on the policies are quite text heavy, so you don't have to read them. They will be circulated afterwards, I think. So the idea is to provide useful reference for you, and don't try and read them all. You'll have a chance to look at them afterwards. I'll also go into a little bit about some kind of tips for people at National Landscapes partnerships or interested in national landscapes. How to engage in the examination process for an NSIP. And I'll cover some examples of mitigation and compensation that we've secured in national landscapes. And I'll leave you with some resources for things to look at, to do some research, kind of in your own time outside of this. So, what are NSIPs? So, here we go. So NSIPs are nationally significant infrastructure projects. They're decided by the Secretary of State, not the local planning authority, following examination by the planning inspectorate. They are decided under a regime that is controlled by the Planning Act 2008, not the Town and Country Planning Acts. And the NSIPs are defined quite tightly by the Planning Act. I think there's 16 different categories of it. There's a schedule to the Planning Act which defines thresholds for the scale of these different types of development, that determines whether they fall into the NSIP regime or whether they need to be decided the usual way through town and country planning. There are 5 fields of NSIP which are defined in the Planning Act. There's energy projects. The Secretary of State who makes the policy for these and who decides them is the Secretary of State of the Department of Energy Security and Net Zero. You have transport NSIPs, unsurprisingly, kind of governed by the Secretary of State for transport. You have water NSIPs, for which policy is written by DEFRA. Wastewater NSIPs also DEFRA. Waste is a bit of an interesting one because I think the policy is written by DEFRA, but I have seen some waste NSIPs which were determined by the Secretary of State for levelling up. So slightly anomalous position there, but I'm sure that's kind of a bit of an anarchy point. So some of the key differences with the Town and Country Planning Act regime. Under the Planning Act, national policy statements have primacy over local planning documents or framework, and actually, indeed, national policy statements actually take precedence over the NPPF. So, under the Planning Act, the Secretary of State must make their decision in accordance with the national policy statement. They then must have regard to other matters which are important and relevant. The local plan is one of those important matters, and so is the NPPF. And the degree of importance and relevance is something for them to decide for each decision. It is not kind of automatic that local plan policy or NPPF policy will be kind of taken, as the text says, particularly where it's in conflict with the national policy statement. Another difference with the Town and Country Planning Act regime is that instead of kind of the outcome of the process being a planning permission, what you get is a DCO or a development consent order. So a development consent order is a statutory instrument, and that is as much kind of part of the law once it's made as an act of parliament. And you're probably already familiar with statutory instruments in the form of orders and regulations and various other things, usually kind of made by secretaries of state. DCOs go quite a lot wider than just planning permission. They can also cover powers for compulsory acquisition. They can cover a variety of licenses which are dealt with by other bodies like Natural England or the Environment Agency. And they can also do a huge amount kind of to interfere with streets and some of the various kind of statutory they can actually modify quite a variety of kind of other statutory enactments kind of as they see fit, as long as they're justified and agreed to by the Secretary of State. The last difference between NSIPs and town and country planning applications is kind of the big difference between how consultation and engagement is dealt with NSIPs. So with a town and country planning application, you might get some informal consultation before the application is submitted, and then there'll be a formal consultation kind of quite often over like a 3-week period. while it's being decided by the planning authority, and then it's decided pretty much. With NSIPs, you will have often quite a long period of non-statutory consultation, upwards of a year, quite often kind of like 3 years or so, depending on the complexity of the project. You'll then have a formal statutory consultation, which usually includes kind of a draft environmental statement called Preliminary Environmental Information Report. Then it will be submitted to the planning inspectorate. And then there follows a 6-month examination process. And the examination, I think kind of the closest analog in town country planning is like a local plan examination. So it's kind of an inquisitorial process where a panel of inspectors will basically preside over an examination holding issue-specific hearings and kind of inviting representations from interested parties and the developer. And so that's a really intense kind of period of work for anyone who's involved in it, particularly local authorities who tend to have to be there throughout the whole thing, adhering to the time deadlines set by the examining authority. So I'll just go to look at kind of an overview of the national policy statements and kind of the whole kind of sweep of them. So there is a whole suite of national policy statements for energy, which I'll cover in more detail in the next slide. There's also a set of national policy statements for transport. So you've got the NPS for national networks, which is essentially road and rail. You've got an NPS for ports, an airports NPS, and those are all Secretary of State Transport. You then have the DEFRA NPSs. So there's an NPS for hazardous waste, one for wastewater, one for water resources. And then you've got the geological disposal infrastructure NPS, which is for geological waste disposal for nuclear waste, essentially. Don't think that has been used yet, and I think a geological disposal facility is quite a long way in the future before that NPS will be used. As you can see from the dates there, most of them are kind of designated at some point in the previous decade. And the NPS for Energy Suite has been updated recently. I think the NPS for water resources was designated for the first time in, I think, September last year. April last year, after having been in draft form for quite a long time. In Suffolk, I think the energy suite of NPSs is probably the most relevant because of the huge kind of amounts and variety of energy projects that are coming forward. So I'm going to spend a bit of time going into more detail in terms of what these NPSs say. So it's important to understand the way that the suite is structured. So you have an overarching national policy statement for energy, which is known as EN1. You then have a number of technology-specific national policy statements. There's a national policy statement for natural gas electricity generating infrastructure, EN2. Renewable energy infrastructure, EN3. This is one that you see a lot of use in and around Suffolk. I'm going to skip to electricity networks infrastructure in EN5, another one that's going to be seeing a lot of action in Suffolk in the near future. You then have the NPS for nuclear power generation, and this is for projects which are capable of being delivered up to 2025. So that is obviously, there aren't going to be any more nuclear power stations coming forward that could be developed prior to, that could be deployed by 2025. So that one is being kept in place because it's still going to be relevant for projects that are currently being built. And there is a proposed NPS for nuclear power generation from 2025, and that's going to be EN7. So this whole suite has recently been updated. So, and what I'm going to talk to you about are the kind of updated versions of these. And some of the kind of important differences, particularly in terms of how energy needs are kind of treated as a critical national priority in the new suite of energy NPSs. But before getting on to critical national priorities, I'm just going to do a bit of an overview of kind of some of the overarching policies. So these are the kind of dreaded text-heavy slides that I mentioned earlier. So I'll just kind of rattle through some of the overarching policy here that's contained in EN1 about landscapes. So one of the first things that EN1 says about landscapes is that virtually all nationally significant infrastructure, as energy infrastructure projects, will have adverse effects on the landscape. So there is no expectation that an NSIP for energy will kind of get to the end of the examination and it will be concluded that there's no residual effects on the landscape. The expectation in policy is that they will have effects on the landscape. But development proposals located within designated landscapes, i.e., national landscapes, or I think AONBs as they are described still in the even in the updated version of the energy MPSs. The Secretary of State should be satisfied that measures which seek to further the purposes of the designation, so you do have a reference to the updated duty there, are sufficient, appropriate and proportionate to the type and scale of the development. That's quite an obvious policy there, basically giving effect to that duty that's been talked about this morning. For projects which may affect the National Park, the Broads or AONBs, the assessment should include effects on the natural beauty and special qualities of these areas. Another very obvious policy, that's nothing new, that's something you would expect from any planning application, really, in a designated area. You have, when considering applications for development within national parks, the Broads and AONBs, the conservation and enhancement of the natural beauty should be given substantial weight by the Secretary of State in deciding applications for development consent in these areas. The Secretary of State may grant development consent in these areas in exceptional circumstances. So, although it is clearly very important for the Secretary of State to give quite a lot of, spend quite a lot of time considering the impact of this on the AONB, it's clear in there that development consent in those areas is expected to be capable of being granted. And then finally, the Secretary of State should ensure that any projects consented in these designated areas should be carried out to high environmental standards, including through the application of appropriate requirements where necessary. So, although they are expected to be permitted in these areas, they are expected to have a high level of kind of control over what the proposal is and how it is carried out. I'm going to go into a little bit of detail on how the MPSs treat electricity networks, i.e. kind of grid transmission lines. So the default position kind of everywhere for transmission lines is that the government has a presumption that overhead lines are the starting point. And the policy says that this presumption is reversed when proposed developments will cross part of a nationally designated landscape. So, in other words, the developer should start from the point of view that in designated landscapes like national landscapes, any kind of transmission line should be underground. However, undergrounding will not be required where it is infeasible in engineering terms. And then to a bit that's less relevant for national landscapes, or where the harm that it causes is not outweighed by its corresponding landscape issue and natural beauty benefits. I think, the previous part about the reversal of the presumption is pretty clear that, where, in national landscapes, the harm will be outweighed by the landscape benefits. The Secretary of State should have special regard to national designated landscapes for the general presumption in favour of overhead, which should be reversed in favour of undergrounding, and that's just making those points clearer. So, some pretty, ambiguous policy there, and I think it's pretty much what you'd expect. But I think where's been really interesting is where the newest set of national policy statements has introduced this concept of a critical national priority for low carbon infrastructure. So low carbon infrastructure is defined as all energy generation which does not involve fossil fuel combustion, as well as natural gas fired generation where it is carbon capture rate. And that's pretty much all energy generation projects that we're likely to see in this area kind of coming forward. Also included in that definition are all power lines and associated infrastructure in the scope of EN5, the National Networks NPS, and other energy infrastructure which, and this is a quote, fits within the normal definition of low carbon, which is very broad indeed. It doesn't provide a specific definition, it just says the normal definition of low carbon. So it's up to the beholder to understand what that means. And then when you get to the meat of the policy about critical national priority, what it says is the overarching need case for each type of energy infrastructure and substantial weight which should be given to this need is the starting point for all assessments of energy infrastructure applications. And this is the really important bit. As a result, the Secretary of State will take as the starting point for decision making that such infrastructure is to be treated as if it had met any tests which are set out within the MPSs or any other planning policy which requires a clear outweighing of harm, exceptionality, or very special circumstances. And this includes where development in nationally designated landscapes requires exceptional circumstances to be demonstrated. So all low carbon infrastructure is treated as though the benefits clearly outweigh harms. They're treated as exceptional or very special circumstances just by virtue of the type of project that they are. And this applies to the National Plan Policy Framework exceptional circumstances test in paragraph 183. This policy does have broader implications than just national landscapes. It will also apply in kind of things such as where similarly phrased tests are given in terms of biodiversity and heritage, for example. But obviously, the important thing for us is national landscapes. So I think what the implications of that are pretty, they require some unpicking for development in national landscapes. What it essentially means is that once you've got past, of mitigation and compensation, any residual harms, essentially that get carried forward into the planning balance don't really get taken any further. It's not expected that residual harms will kind of form the basis of outweighing the benefits of the project. They're not going to be a reason for refusal of the project just on those grounds. So I think what that does for those of us who work in national landscapes means that when we are responding to nationally significant infrastructure projects, we need to focus a lot more on what we can influence in terms of the design of the project, what mitigation is offered, to what extent any compensation is offered. And I think we're going to have to give very kind of proactive representation about what we actually want out of the project so that they can meet those, so they can actually provide something rather than going in with the expectation that we'll be able to prevent any kind of development, any kind of low carbon infrastructure development. So that's the policy, and you can kind of see all those references when you look at the slides later on. So some tips for national landscape partnerships. I think the most important thing probably is to understand the impacts of a project early on and define them in terms of what the impacts are on the special qualities of your national landscape, because the more specific and articulate you can be about how this particular project impacts those special qualities, the more likely it is that you'll be able to make a strong case in favour of any particular method of mitigating a project. Figure out what's possible in terms of the mitigation hierarchy, so avoidance, mitigation, compensation, and advocate it before and during the examination. So, rather than saying, this project's going to cause a lot of harm and leaving it there, figure out what you actually want, what do you want changed about the project, and say so from an early stage. I think giving the examining authority or the Secretary of State a clear option in terms of what they should do instead of the applicant's proposal is really important, and it's kind of a way to make it easier for them to agree with you. And by, when I say, alternative, I don't mean big picture alternatives when it comes to a particular project. I mean kind of the details of the design, how the management plans deal with, protecting, landscape features and so on. But it's kind of more on the micro scale than the macro scale of, of kind of project design, I think. Engage in an ongoing conversation with the developer from an early stage. So you have more ability to shape the project the earlier you get involved. Partly that's because, at an early stage, the project is less solid in the developer's own mind. So it'll be easier to change their mind about what it looks like and change their own conception of the project. The other reason is kind of a technical planning reason, and that is that once you get into the examination, it becomes very hard to introduce changes to an application. So if the developer wants to change their proposal for an application partway through, they need to convince the examining authority that that change isn't a material change. They need to undertake a greater or lesser degree of consultation outside the examination process while it's going on. Before they do that, it becomes very kind of technically challenging to do. And in a 6-month examination timetable, it can become very difficult to do that in parallel to the examination and introduce it to the examination and have any subsequent issues raised by that change examined thoroughly in that period with what time you've got left. And the 6-month examination timetable is a very strict limit on examining authorities. They can, in theory, apply to the Secretary, ask the Secretary of State for an extension to that. But I'm only aware of that happening once, and that was because of exceptional circumstances in relation to the pandemic. So, for a variety of reasons, if you want something changed, see if you can get it changed early. But, you can still maintain your position throughout the whole examination and after it. But you've got a greater chance of success the earlier you go. I would also say collaborate with the host authorities, especially on the local impact report. So just to explain a little about the local impact report, that's a document that the examining authority will invite the host local authorities to produce. And it's important because it's one of the only documents that is specifically named as something that the Secretary of State must have regard to in making their decision. So it's on the same level as other important and relevant considerations, but it's the only specifically named document. So that's a really important technical document that will be presented at the beginning of the examination. And if you can have, the qualities of the national landscape really front and centre of the chapter of the local impact report that deals with landscape issues, then it will put you in much better stead for having your arguments kind of substantiated and landing as the examination goes on. So I will say here that the local impact report is a document for the local authorities. They don't have to kind of invite broad kind of contributions on it. And due to the timescales, that's often not possible. But as a local authority banner, I would want to talk to the National Landscapes Partnership to be sure that we're on the same page about what's going in there. So not a broad appeal for contributions, but I think a local authority will definitely value that input from the National Landscape Partnership. I'll just cover very briefly, because I think we are running out of time, some of the mitigation and compensation that has been achieved in the Suffolk Coast and Heaths area. So on the slides we see nuclear power station. I mean, this is a different scale of development to pretty much all nationally significant infrastructure projects, and it has a much larger set of mitigation proposals to go along with it. There is a Natural Environment Improvement Fund, There is an informal recreation and green space plan. There is a land management and skills scheme, which is aimed at kind of improving skills in, in kind of conservation work in the area. And you've got the landscape and ecology management plans, which are a really common feature of NSIPs. And East Anglia 1 North and East Anglia 2, we secured funding for improvements to the landscape, ecological and access improvements in the vicinity of the project. So, there is often compensation and funding available if you can make strong arguments through the examination. I think I'm just about at the end of my time. So what I'll do is I'll just leave you with kind of a set of resources which I've included in my slides to direct you to things you can read if you're interested in diving into the world of nationally significant infrastructure projects. Thank you.
Right, thank you, Isaac. Our final speaker today is Ross Walker. Again, an officer from Suffolk County Council, graduate of University of Exeter, who's currently working for Suffolk as a senior planning officer and is lead implementation officer for biodiversity net gain within the planning department. So once the IT is sorted, we'll hear from Ross.
Good afternoon, everyone. Just while I sit now, I'll introduce myself. As been stated, I'm Ross Walker, Senior Planning Officer at Suffolk County Council. While they're loading the slides, I'd just like to make a confession. For a number of reasons, all the images that you'll see in my presentation were AI generated. This was to do with copyright issues, and it's very hard to find large expanses of blue sky at this time of year. So, it's all right. But yeah, so today's presentation is going to be about the wider biodiversity duty, focusing on biodiversity net gains and local nature recovery. I realise not everyone in this room is a technical planner, so I'm not going to come at it from the view of boring you all to death with technical planning information, but I'm going to try and give a more succinct overview of what is biodiversity net gain, why a change in approach is needed, and how this will continue to contribute to nature recovery. Now, on my slides. Is that right?
They're coming.
They are coming. Okay. Which side in?
Yeah, you could.
So, biodiversity net gain, or BNG, represents
the box before you go.
Of course. So, biodiversity net gain, or BNG, represents a pivotal shift in environmental policy, aiming to ensure that development results in quantifiable increases in biodiversity. But what actually is it? Biodiversity net gain is an approach to development which leaves the natural environment in a measurably better state than it was before. The key part of this statement here is measurably better. The environment acts as the first point at which habitat loss and mitigation can be officially measured and quantified in a uniform way. The approach to delivering BNG will still require the use of mitigation hierarchy. First avoid, then mitigate, and then as a last resort compensate. This should sound familiar to many of you in the room. It's been picked up on previous presentations. But just to clarify the difference between mitigation and compensation, as it is a subtle difference. Mitigation is defined as actions taken to reduce or prevent the impact of a problem or risk, whereas compensation is the provision of something valuable to make up of loss, damages, or negative impacts. For an example, in this area, protecting a hedgerow from grazing animals to encourage a stronger development of that habitat would count as mitigation, whereas compensation would be to pay for a woodland to be planted elsewhere to offset unavoidable loss of woodland. Where losses cannot be compensated within the development footprint, biodiversity losses may be offset and delivered elsewhere. This in itself represents a change in approach. Previously, development was required to mitigate harm and provide compensation where possible, but it was not very common for specific off-site mitigation to be secured to compensate loss, and those specific levies do exist for certain environmental things. Not only does the Environment Act open this up as a simple avenue for compensation, but it legally requires it where mitigation cannot be delivered on site. So why do we actually need to improve and enhance our biodiversity, and why is it suddenly so important now? The idea of nature recovery and biodiversity isn't new. Recent milestones in the UK include the 2019 State of Nature report. It was published and stated that the abundance and distribution of UK species has on average continued to decline since 1970. Practices such as intensive agriculture, climate change, non-native invasive species, and land use changes have all been drivers of biodiversity decline. As previously mentioned, management of the environment was aimed at preventing harm more than securing quantifiable increases to biodiversity net gain. A change in direction is crucial to addressing the escalating and ongoing habitat decline. By prioritising net gain, we not only protect and enhance the natural environment, but also ensures continued provision of vital ecosystem services such as pollination, water purification, and nutrient cycling. The Environment Act addresses this by mandating development to provide measurable environmental benefits through development, though currently I will say it's only in effect for major applications, and the scope will widen in the future. So across the country, the goal is not only to reverse habitat decline, but to actively work to increase the biodiversity and size of habitats, linking them up on a nationwide scale. This can be done by creating and enhancing a series of interconnected habitats across the UK to join up in a national network. I do appreciate that the current approach to BND is habitats-led, but as the theory goes, if you build it, they will come, and this should lead to an improvement in species. This change will be brought about through the government's 25-year environmental plan and the Environment Act, and the legislation is specifically designed to safeguard the environment by ensuring that development activities do not only avoid harm, but actively contribute to quantifiable enhancements of nature, landscape, and the environment. The planning system plays a crucial role in delivering biodiversity net gain. A lot of the habitat improvement will be implemented from a ground-up approach, with environmental uplift being delivered through planning applications. Through the engagement of professional ecologists and the biodiversity network, we can quantify biodiversity as a figure and relate it to development. Developers will then be mandated to implement measures aimed at achieving this BNG. Monitoring and enforcement measures within planning will ensure that BNG commitments are upheld, and the planning system will also facilitate the collection of national credits and funnel this national credit money towards national nature recovery, which I'll go on to talk about shortly. The Environment Act with the Environment Act comes a few new elements to the planning system, most notably the use of the biodiversity metric, compensation habitats, and the Natural England Net Gains Register, which again I'll cover in a bit. It is worth mentioning at this point that BNG actually gets assessed twice during the application. So once within the BNG statement, which is submitted with the planning application. The job of this is to simply outline the baseline on site and then almost develop what uplift can be achieved. And then secondly, after the application has been determined, but before it can be implemented, so this is a mandatory pre-commencement condition, the developer will be required through the submission of documents to outline details exactly how they will achieve this level of biodiversity net gain. And it's very important to note that the project cannot progress past this point until that condition has been discharged. It would be in breach of planning. So we touched on the mitigation hierarchy earlier. I think Isaac touched on it as well, but here it is again: avoid, mitigate, compensate. But now when we get to compensation, we have another level of hierarchy for delivery, and that goes on-site habitat compensation, off-site habitat compensation, and then the national credit scheme. But I'm just going to take a minute out here to touch on the biodiversity metric as it's used to calculate the on-site, off-site habitat provision. It's worth mentioning that this is the metric of improved development in the last number of years. We're currently using version 4.0, and this is the one that's expected to be submitted with planning applications moving forward. The metric is a very important mechanism for assessing BNG. It is able to quantify loss and compensation with a uniform measurement that can be used by everyone. The metric does this by providing a standardised way to quantify the biodiversity value of different habitats and landscapes. It will assist all parties, local authorities and developers to assess the potential impact of development on biodiversity by comparing the biodiversity of the value of sites before and after and taking any harm into account. The way the biodiversity metric is structured, it splits habitat into 3 different sections, habitats, linear habitats and water habitats. These 3 sections are then in turn broken down to include every habitat type within reason: woodlands, grasslands, wetlands, hedgerows, urban green spaces, you name it. The end use of the metric will be key to ensuring good design and provision of BNG down the line. And this is a key tool in measuring biodiversity. I cannot emphasise how important this is. It essentially underpins the whole concept of BNG being able to deliver measurable gains. So, if it's established that habitat compensation is required, the first option is on-site habitat provision. Developers are advised to deliver as much on-site compensation as possible. However, if only part of the mitigation can be provided on site, and it can be split between on-site and off-site provision. I'll cover that again in a bit. On-site provision will be the most effective way in addressing harm caused by the local environment, and it will also likely be the most cost-effective mechanism for the delivery of this. Considering biodiversity net gain and using the metric at an early stage of the design process will help to achieve better local outcomes for biodiversity and will avoid the need to retrofit biodiversity net gain measurements at a later stage in the process, which will most likely result in a more costly design or an ineffective design or having to spend more money on additional off-site habitat. So, the developer should only consider off-site biodiversity net gain delivery if all options to reduce harm, loss or damage on site have been considered. It's essentially, as it says in the name, delivering compensation habitat, which is away from the site of the development to offset any harm which cannot be mitigated on site. Off-site habitat provision can be undertaken to provide all or part of the scheme to require 10% to achieve the 10%, but as we previously touched on, it is heavily encouraged to provide as much mitigation as possible on site through on-site delivery. Any off-site habitat provision or enhancement must be secured through the Natural England Site Register and require a legal agreement in the form of 106 or conservation covenant before this land can be registered on the register and your obligations as a developer is fulfilled. If for some reason it is deemed not possible to be able to provide any mitigation on site and there is no feasible option for off-site mitigation, then developers may purchase national credits to offset their scheme. This route will have to be agreed between the developer and the planning authority before credits can be purchased, and this is intended to be a last resort. It's not your kind of go-to in the first instance. Now, before I show you the next slide, I'm just going to stipulate the prices you're about to see are for the National Credit Scheme. As I mentioned, they are for a last resort delivery of BNG. They will do the least to mitigate the immediate local impacts of the development, and the prices are reflected as such. National credits are to be priced to encourage an active approach to delivery of BNG over simply paying the levy and kind of ignoring your responsibility to compensate damage. It may actually be more cost effective for developers to over-deliver on their sites if possible and then sell the excess units on, rather than value engineering their scheme down to 10%. Local off-site credits, however, will be subject to market pricing and will vary dependent on the scheme. I personally haven't seen any of these traded yet. If anyone has, please do let me know what they cost, but we expect them to cost about half of what you're about to see. So, as you can see, these credits are not cheap. The table shows an example price for each tier of credit, and you can see the price depending on the habitat being compensated varies greatly. Even at half the rate listed behind me, off-site compensation could end up being quite expensive. further highlighting the importance of on-site habitat provision where possible and designing a development to incorporate as much as possible into the initial stages of design. I've said this many times before I'm done today. For example, if your development was required to compensate the loss of an alkaline lake, and you could not find a local landowner who had an alkaline lake who was willing to do a bit of uplift for you, you'd have to purchase a national credit scheme, and you can see that's £230,000 a unit. Again, this is not an easy option and a simple get out to ignore environmental management. While this does all sound like a lot of money, and I have made that point, environmental management can be expensive. So this will cover the cost of implementation, 30 years of monitoring and maintenance, and the seller of the land and units will need to factor this in as they will become liable if they don't deliver over the lifetime of the scheme. Any landowner will also need to factor in 30 years of land loss, especially if we're taking land out of agricultural production. It's unlikely that that land will be returned to the farmer after 30 years because there will still be the requirement to provide an additional uplift on the uplift already provided. It's also worth mentioning that any financial agreements are attached to the land, so if sold, the commitment remains. So, as mentioned, any mitigation provided off-site needs to be secured through a legal agreement, section 106 of conservation covenants. Just on conservation covenants quickly, no one in Suffolk has yet signed up as a responsible authority, so the only route at the moment is a section 106 legal agreement. And they'll have to be uploaded to the Natural England Register of Sites before they're official. This not only provides an accurate record of compensation sites, but also prevents double counting or double selling of units between developers and landowners. Your mitigation is not official against your application unless it's registered on this register. The register, however, will not act as a market platform for buying and selling units, and this will probably end up being done by the private sector, nor will it assess the ecological suitability of proposals. So, we've seen how BNG will be implemented through the planning system. Now we're going to look at a bit how this will help to deliver nature recovery. A key exercise in this area will be the production of the local nature recovery strategies, which play a vital role in setting priorities for local nature recovery across specific regions. These strategies are essential in mapping valuable areas for nature, identifying key habitats, and the needs for conservation, restoration and enhancement. The LNRS will provide a blueprint for how Suffolk local communities, landowners, local authorities, private companies, government bodies can all work together to broaden protection, restore and recover nature on the ground. Local nature recovery strategies will essentially help to direct biodiversity improvements towards nature recovery networks so they can be the most effective. So, Suffolk, Norfolk and Suffolk producing their local nature recovery strategies in partnership. This will generate two separate local nature recovery strategies, taking each other into account, also taking into account the interconnected habitats within East Anglia. This approach was taken as it was thought it would generate a more accurate, usable strategy across the two counties. Now, LNRSs are not expected to be in the public domain until about 2025. So if anyone did want to know where to direct their off-site mitigation in the meantime, please refer to the Suffolk list of priority habitats. So there were 48 local nature recovery strategies created across the country in the next 2 years, and together these will form the National Nature Recovery Network, ensuring that nature is bigger, better and more joined up. It also provides a blueprint for delivery of new duties and funding streams such as BNG. The image you see there is not actually a nature recovery network map because they don't exist yet, but it will look similar in nature and it will identify key habitats and ways that they can connect corridors. I was going to show you a video at that time. Oh, right. So improving biodiversity is not just about BNG uplift through new development. There is a wider biodiversity duty introduced by the Environment Act, and under this, authorities must consider what can be done to conserve and enhance biodiversity, agree on policies and specific objectives, and act to deliver these policies and achieve these objectives. Suffolk County Council identified targets to work towards improvement of biodiversity across the country. The most prominent example of this is the 30 by 30 pledge. The council will provide an uplift of biodiversity across 30% of its land holdings by 2030. And I hope I've got that description right, but Tim's going to tell me off later. Biodiversity will be delivered alongside other aspects of environmental management, for example, the pledge for zero carbon by 2030. I've just mentioned flood risk and mitigation here. They don't strictly have a role in providing biodiversity net gain, but flood mitigation strategies are becoming more and more environmentally focused, and there is the opportunity to tie them quite well into PNG schemes in the future. Now just going to quickly look at a case study from coming out of Suffolk County Council. So this is the site that might be brought forward by County Farms to deliver a biodiversity net gain. The site's in West Suffolk to the east of Bury. I can't give you the exact location just yet, but it's roughly there. The site is 29 hectares, and baseline assessments have shown that 60 units of habitats and 11 units of linear habitats are present on the site. No watercourse habitats, if you were wondering. So a couple of different scenarios were modelled. In the end, 2 draft proposals were being considered, one with ponds that you can see in the image and one without. Just if anyone was wondering what that picture looked like before the proposal, it was a blank white square. It is unlikely that the ponds will make the final design, not because they're not an important ecological feature, but because further investigation found that due to the geology of the area, the ponds would most likely fail. By improving the grassland habitat from agricultural land and adding habitat features such as hedgerows, additional woodland habitat, it's calculated that an uplift of 133 units of habitat and 20 units of linear habitat could be achieved. This is quite a lot. This is quite a large amount of uplift, and if you were to do the maths based on the previous slide, you would see how much money that's worth. Looking at this design, I just say the hedgerows currently running, those blue lines running kind of across, they'll most likely end up going north to south. And originally, interestingly, the reason for this is because the wind direction blows from east to west, which means if you realign the hedgerows, they can act as natural seed traps, which will contribute to a more natural regeneration of habitat. And it's examples of this, like this, show why it's so key to involve an ecologist in the earliest design stages, as they can be invaluable as to the effectiveness of the schemes at the end. So when people talk about agricultural land, you probably have a picture in your head about a large expanse of rolling fields, which due to their nature have limited capacity to support long-term biodiversity. I mean, arable fields by their nature have their crops rotated several times a year, and they're normally over-fertilised, I would say. I don't know what the technical term is, but it doesn't allow for a lot of other kind of species to take root. However, as you can see from these pictures, these sites can be home to a number of environmental features which can be enhanced and used to improve the wider biodiversity. Just on this site, we have the World War II pillbox, which when we originally looked around the site was thought it could be used as a bat home, but it's already been taken over by overwintering peacock butterflies, which just shows stuff is going on here. And around the boundary of the site, there are more habitat features to be found: bramble scrub, tree lines, hedgerows, the proximity to an established woodland. All of these features can be enhanced to bring forward more valuable habitats.
1 minute.
I'll be quick. As mentioned before, PNG is currently only in force for major applications. Minors and NSIPs will follow. Minors are actually coming to a force on the 2nd of April, which is not very long away. This is likely to significantly increase the number of PNG applications which local authorities will have to determine, but it will allow the use of the small site metric, which is slightly less onerous. I won't go into that now. The date for NSIP has not been defined. The government is likely to hold a consultation in 2025, which would mean an implementation date of 2026. And I'll just quickly say some local authorities may be exploring the opportunity to provide more than 10% net gain. While aiming for higher levels of net gain can demonstrate a commitment to safeguarding the environment, it can also increase costs both the developer and the local authority, and even in some instances stifle local development. Having just touched on them SIPs, I'll just quickly say these are an area where a higher level may be able to be achieved, simply due to the fact that they can cover a lot of land which is not necessarily allocated to development. But this will most likely be covered in the government consultation. So, final slide. Although B&G has only been in force 1 month, we have a long lead up time to this. We've known this has been coming since the back end of 2019. So there are three, I'll just do the 3 main points. This will require additional resources, both from the developer and the local authority side. The requirements to have a competent professional assessing B&G applications, metrics and design is just one of the elements that will place an additional burden on authorities. Especially those who don't have an ecology department in-house at the moment. This will also have an impact on developers as they will require an ecologist input as early as possible to secure effective designs. The second point would be that collaboration is key. I've said this before, I'll say it again. Especially in a process like B&G, where the guidance from central government may have been slightly more reactive and precautionary in this instance. Collaboration between development and the planning authority is key to getting applications correctly assessed under the new regulations and prevent delays. And my third and final point is simply early engagement with the metric and the use of an ecologist in design is key. If all elements, procurement, landscape design and building design can work together with the metric and suitably qualified ecologists, and their designs will implement maximum amounts of B&G at the earliest stages on site. This will result in more cost-effective, more useful designs and will help reduce any retrospective changes during the delivery and construction, which could, increase costs further down the line. I've just finished by saying B&G is a 30-year commitment. We are likely to encounter problems not known to us at this point in time. However, this is another reason why communication and collaboration are absolutely vital. So I hope you have a better understanding of biodiversity net gain and how early engagement and good design can result in a cost-effective delivery of habitat recovery. Thank you.
Thank you very much, Ross. There's an awful lot to
Sorry,
cover there.
yeah.
We probably could have spent the whole day focused
Could have done a few hours
on that, so you've done really well. If you could stay up here and Isaac join us, we'll open for questions, please. Thank you.
Yeah, Chris Wilson from Together in Consultancy. Got questions both to Ross and Isaac. This is on the back of spending the last 4 years trying to protect the area from the sort of damage that tidal seas can cause to the designated landscapes. With regard to the biodiversity net gain, I noticed from the slide there was no mention of the damage to the marine environment. You take tidal sea as an example, hundreds of millions of fish will be killed every year for 60 years when it's operating with a cooling water system. There doesn't seem to be a net, which is very much a negative impact on biodiversity, especially with the RSPB reserve and the need for the birds to have the fish to eat. And the other thing, the experience from tidal sea under this BNG is that some of these replacement habitats take a long time to develop. I mean, for example, there's wet woodland, and they don't know whether that level replicates itself, and how that. So, you must know how that will be dealt with. And a question to Isaac: with the change in the Levelling Up Act 2023. Would that have changed the council's approach to the tidal sea development? I appreciate the county council aren't the decision maker there, but obviously you've got the local authorities impact report. Would it have changed it? Because from looking at it from the outside, it seemed like the county council, and particularly the Suffolk council under the old regime, they've pretty much an open door to EDF for all the damage that was being caused. So I'd just like to know whether that will actually affect NSIPs moving forward. Thank you.
Sorry, just for the questions on B&G, I do agree with you. Marine habitats are incredibly important. They're not really captured under the Environment Act and the current metric, but there are separate offshore marine plans being produced at the moment. I think we fall in the I think we must fall in the southeast marine plan. I think there are two that cover East Anglia. One of them goes just south of Ipswich, and the other one kind of carries all the way around to Norwich. I think it's something that should be considered in the future, certainly. But if you wanted to look around that more, there are offshore marine plans that will be addressing those issues. I remember the second point was, I'm sorry.
How long the benefits will take?
Yeah, so it's quite hard to kind of talk about what should have been done on Sizewell C, because it was, this has been planned before the Environment Act, so it's kind of been thought of, and Sizewell C has been in the game for a long time. But moving forward, when we do have the Environment Act being applied to NSIPs, it's simply a matter of any piece of habitat or any quantifiable part of biodiversity that they have removed or damaged will simply have to be replaced like for like, either on site or somewhere elsewhere, or they can pay into the national credit system. And again, that is a kind of, it could essentially be seen as negating responsibility by just paying money, but the costs involved in that, it would be, I'd be very surprised if it wasn't actually cheaper and more cost effective to just take an active approach in replacing the habitat than it would be to be throwing millions of pounds at something like replacing a lake or an ancient woodland. I mean, if you're planning development near an ancient woodland, I just would not bother. The amount of costs that it will involve moving forward are insane.
So in answer to the question about the new duty on statutory on public authorities, so I think the kind of narrow technical answer is that when a local authority is responding to a nationally significant infrastructure project, it's not really kind of in their role as a public authority making a decision. So you kind of look to the DEFRA expert there has given me a nod, but I think that's the kind of narrow technical interpretation, is that it doesn't really engage that duty when we're responding to an incident. I don't think that I don't think it's strictly fair to say that we kind of didn't take that kind of approach in general. And I think we did take quite a robust on impacts on the AONB, and we've got some fairly kind of ambitious arguments, kind of going above and beyond kind of what was required by policy there. For example, there were kind of a series of kind of national grid pylons which would be required to connect Sizewell C to the national grid substation. It was our view that those weren't necessary, that they could be dealt with through either an underground situation or a reconfiguration of those pylons. And we pushed very hard to get Sizewell to change that, to the extent that we commissioned engineering reports from electrical engineers, which is something that is kind of quite far beyond what we usually do in response to a planning application in terms of trying to reduce the harm on the OMB. And I think we did involve the OMB as it was at the time of the examination. And we did spend quite a lot of effort, and we actually included a whole chapter in our local impact reports about impacts on the AONB separate to more general landscape and visual impacts. Although strictly the duty wouldn't apply to us, I think I would kind of maybe challenge the question a little and say actually we did put quite a lot of effort into kind of preserving the statutory kind of the special qualities and statutory purpose of the AONB as was at the time. Thank you. Sorry, I hope that's not too annoying.
Sorry, the NRS in Essex is quite advanced. The opportunity mapping, or the opportunity map is under various stages of consultation, but quite close. Where is Suffolk with an equivalent, and are you doing an opportunity mapping? If you are, with Essex, there's been problems with them taking out AOMBs, SSSIs as constraint sites, which had a negative impact in saying there's no opportunity to improve biodiversity environment in those sites or indeed adjacent to them, i.e. expanding them.
You might be better answering that. Yeah. Sorry, Tim is our head of natural environment. I don't work within the LNRS team myself, but he's going to tell you about mapping.
Tim DeCarza from Suffolk Council, so I actually am working directly on the LNRS, which Ross referred to. Thanks for the question. Yes, we're speaking with Essex quite regularly, because we do need to make sure these strategies join up across the boundaries, but as Ross said, we're working closely with Norfolk in particular. I don't know the detail of what the mapping in Essex is doing, but the requirements on us in terms of mapping are very clear and very specific within the regulations, and they will be, in my understanding, broadly consistent across the country through all 48 local nature recovery strategies. I'm not sure what you're referring to in terms of removing protected sites from the strategy. I can't imagine why that might be the case. The stages of the process are that we have to define all of the existing areas of biodiversity importance, which would include those areas that you referred to. And we then need to, from that basis, identify the areas of biodiversity potential as part of the strategy. But that does not negate the importance of those existing areas. It merely reflects the fact that they may guide how the strategy is actually determined and where we should focus our collective efforts to achieve that nature recovery towards that national nature network, which is what the Act is aspiring to do. So I think you'll see that begin to emerge as the strategies develop further. We have done all our mapping, that first stage mapping. We just haven't released it publicly yet because we're doing some further checks on it at the moment. As I say to people who make this point, it's not a race. You know, it's about getting it right. So we're trying to work with all of the constituent stakeholders in Suffolk and our colleagues in Norfolk, because it is a real joint effort to develop the best strategy for Suffolk. And obviously that means we need to bring everybody else with us as well. So hopefully that picks up your point.
Any more questions, Brett?
I've got a couple of questions from the online chat. First one is to you, Isaac. Does CMP make redundant a ROPE for low carbon projects?
Short answer is no, because ROPE is, as I understand it, mainly an HRA consideration. So, you know, that is very much still applies for those, and the CMP is kind of for, you know, consideration, you know, ban policy considerations rather than under that's law.
Question for you, Ross. Is the National BNG Register live and are entries made by the local authority? Anyone?
Sorry, what was that second? The end second? Have local authorities registered any land?
No, are entries made to the National Register? Is it live? And how do people register?
Okay.
Is it by the local authority?
So the register is handled and kind of owned by Natural England, so that is how you would register. You would go to the Natural England kind of national level rather than your local authority. Sorry.
Is the National Register?
Yes, it is live currently. So BNG went live on the 12th of February, and so the register should have been kind of up and running on the day or slightly afterwards. I personally haven't seen anyone actually use it yet. It's not simply a case where you can identify what you want and then just put it on the register. For something to be on the register, it has to have legal agreements. These legal agreements contain things like the monitoring. Someone asked a question earlier about how BNG would be monitored. Their monitoring will be secured in their habitats maintenance and monitoring plan. And that, alongside any other information, will be uploaded to the register. So there's an accurate record kept there. Sorry, I answered the question. Thank you. More questions?
Hi. When you showed the map of the areas that would be linked up into a national nature recovery network, you said that the areas that would be linked would be the national landscapes and I suppose national parks and so on. But you didn't seem to include all the other things like SSSIs. Did you?
No, it's probably because running out of time.
Okay, so what so the question I'd ask is that there was a reference made to connecting these different areas by tree planting, for instance. But surely in many cases their best linkage would be along river valleys. In Suffolk we had a system called, I think, special landscape areas, which was very much based on river valleys. It's still, I don't say it doesn't exist anymore, but what a pity that that system was abandoned before this had got going. The trouble with saying that you'll link areas by tree planting on land of willing owners.
I'm not sure I focused on the point that tree planting would be used in their habitat, and if I did, I apologise.
I'm really pointing to a risk of the loss of important biodiverse areas, particularly around towns, that are targeted by developers, and the temptation will be on the planning authorities to say we can grant permission on all of these sites because we now have biodiversity net gain. Will areas in the nature recovery networks count as protected landscapes, or will they simply be areas that get a higher score on biodiversity net gain?
So the National Nature Recovery Strategy is more, it's not about identifying specific designations of habitats, it is more about identifying all the habitats and the ways that they can be connected best. If I did say tree planting would be used to connect habitats, I apologise, because in most cases, as you're right, that will not be the sensible thing to do. Especially if you look at Suffolk, when we go to the north and you go into Norfolk, you do not see large kind of expanses of trees. You have occasional pine lines, but the rest of it is, you know, succession of scrub heathland. So the idea is that that will be replicated where it is needed. If a developer is removing successional scrub or heathland, I mean, I wouldn't advise going after heathland, but they will be required to replace that unit for unit. In terms of whether this will open up land for development that has previously not been developable, I'm not 100% sure. I personally don't see this legislation being used to do that. It is more focused on environmental protection than the delivery of housing. But yeah, okay.
I just had a point on the key designate, just again, to be absolutely clear about the role of the local nature recovery strategy is not to take any designations away from anything, but it equally does not designate anything either. It's a strategy based on what we have and our best understanding of how we can build that in an environmental, build on that in an environmental sense to support nature recovery. So as you rightly say, Nick, a lot of that is around developing and extending corridors in different ways based on the law and principles. You know, that will enable species to move, to expand, and for nature to get, you know, more of a chance. So that's the principle, but it's not designating anything. The strategy will be the strategy. We heard about the new duty in relation to designated landscapes from the Levelling Up and Regeneration Act. That act also put in place some new statutory instruments which will ensure that planning authorities must take account of the local nature recovery strategy in future. That's, I think, exactly what it says. You can have a look yourself, it's buried in the schedule somewhere, but we're still waiting for the statutory guidance from DEFRA on how planning authorities should actually, do that in practice, but that's the principle. Because it's not designating anything or taking any designation away, just to be absolutely clear. Thanks.
Thank you. Again, some really interesting questions, and I apologise, Catherine, I saw you put your hand up, but we have run out of time. If you have got a question, then feed it through with the feedback. Thank you, and thank you for anyone else that missed that opportunity. Could I ask you to thank all our speakers, including our guest speaker? On the top. Thank you. So I hope everyone enjoyed the event as much as I did, and certainly it could have gone on a lot longer, couldn't it? There was so much to learn and take away from all the speakers, I think, today. I mean, for me, there was some key points really around the new duty, what that means. Time will tell. It's good to see that there's going to be some interim guidance at least, which I think everyone will welcome and find useful. Have to admit to not knowing very much about dark skies before today, apart from a very recent appeal decision in the Dedham Vale, where the dark sky was used as a reason for refusal and upheld by the inspector. But who knew that the application of some what seemed like quite simple principles to me could make such a difference? So I'll be sending my husband, who is an electrical engineer, the link to the document, and hopefully we can change some minds. We then turned to NSIPs, and it was really useful to hear, there's so much information out there, but, the difference between NSIPs and the planning system that we're all used to. And, top tips for dealing with projects within national landscapes and the mitigation that's been achieved so far on some of the schemes. And then finally, but by no means least, and I meant what I said, we could have taken an awful lot longer on biodiversity net gain. And, Ross did a really good job trying to cram it into 20 minutes. It is early days for a planning system, as was mentioned earlier. Only time will tell really how successful it will be. And I think the point made about extra resources is critical, because for one, having tried to recruit an ecologist on 3 occasions, they're very hard to find. So I'm sure we're not the only ones struggling with that. So I'm just going to ask Councillor James Finch if you'd like to say a few words in closing. Thank you.
Thank you very much, Karen. Good morning, everybody. You've heard myself lunging in front. Well, what can I say? First of all, if anybody thought having a 18 NSIPs in our project is a simple project, I think we've learned this morning that it's certainly not. It takes a lot of resource. We've had 4 specialists speaking to us this morning, all of whom have actually built knowledge, and I'd like to congratulate them all in terms of what they've contributed to Suffolk. As chairman of the Dedham Vale National Landscape, I have to think every time National Landscape and the Store Value Project, these are going to be more important to us. Having said it's not simple, we've had the experience of the 4 speakers to sort of point us in the right direction. And the other sort of summary, Madam Chairman, is there's no quick fix, is there? And what worries me is that we have these policy statements made by government, and how we implement. I actually started off my comment right at the beginning by trying to summarize, have an active as a national landscape, active duty as a passive duty. There's going to be more activity required from us. Sorry, thank you. More duty required by us all. And then the other speakers have all referred to it, is we've all got to work together. There's no point in pointing figures and saying, well, it's him, it's him. We've got to try and work together and have a solution. So can I ask you to put your hands together and say again, thank you all for the speakers we've heard today, and commit to take the action away. Thank you very much.
Don't forget the feedback forms.
It's across screens.